All right, so corruption of foreign public officials. Um, so consider the following problem. You're a lawyer for a Canadian corporation that has operations in lots of different countries. The regional manager for one of these countries calls you and says that a subcontractor of theirs, not an employee, but a subcontractor, has made some cryptic remarks about giving a present to the child of a government official in that country who's responsible for an important permit application for the company. The subcontractor has said that this is just the way business is done here. What do you do? Is this a problem or not? And I'm sure you will be surprised to learn that it is a problem. It's a serious problem. The reason is the statute called the Corruption of Foreign Public Officials Act. It was enacted in 1998, but it really didn't have very sharp teeth at that time. But it was substantially amended in 2013, and the reason was that Canada was getting criticized again and again for not complying with its treaty obligations to fight international corruption. So since 2013, there's been a much higher profile to these issues and to investigations and prosecutions coming out of this statute. So what do you need to know about the CFPOA? Basically, it creates two offenses. The first one, bribery, is the important one. When you give something to a foreign official as consideration for an official act or omission, or as inducement for them to use influence, that is bribery. And then there's the sort of ancillary offense of the books and records or accounting offense, which is when you make a false entry in documents or destroy documents for the purpose of bribery. Both these offenses are straight indictable offenses. They're not in the criminal code, but they're prosecuted under the criminal code. So they have no summary. They're not hybrid offenses with a summary conviction, less serious form. And they have maximum sentences of 14 years imprisonment. So they're among, judging by the maximum penalties, they're among the more serious offenses in the criminal code. And just to give you some idea, 14 years is the same maximum penalty as fraud over $5,000. Of course, fraud over $5,000 has a monetary minimum. It's got to be over $5,000. Bribery doesn't. So in a way there, you could say it's more serious than some frauds. So what is a bribe? It's one of those things that's quite hard to define. There are obviously very easy cases, and then there are cases that are much more difficult. So the attempt that the legislative draftsperson has made in the CFPOA has 5 elements, the last of which has an or. So there are 2 branches there. So first of all, you're obtaining or retaining, the reason is that it's to get an advantage in the course of business. 2, what you do is you give, offer, or agree to give or offer directly or indirectly. So it's not actually just the giving or paying of a bribe, but it's agreeing with somebody else to offer a bribe. And the person you're agreeing with doesn't need to be the person you're actually bribing. So it includes sort of conspiracy type agreements. 3, a loan, reward, advantage, or benefit of any kind, very broad language there. 4, to a foreign public official or to any person for the benefit of such a person, and we'll get into who a foreign public official is in a minute. And then the 2-pronged 5th element, and this is I think the most difficult one to interpret and apply, as consideration for an official act or omission. And so there'll be questions about, well, what is this person's official duties? And then 2, to induce the person to use their position to influence acts or decisions of the foreign state. And again, there you can imagine that there could be questions about, well, is this payment really to induce this person to use their influence? I mean, these are, I think, broad language that, as a result, can be a bit nebulous around the margins, with raising difficult questions of application. Same thing with who's a foreign official. We have to have some idea of the structure of a foreign government and what the legislative, administrative, and judicial positions are in that government. But it also captures people who perform all public duties or functions, including people who work for boards, commissions, and even corporations. So it includes things like, potentially airlines, energy companies, educational institutions, medical institutions, depending on the degree to which those institutions are controlled by or fulfilling a function that is associated with government. There are 2 saving exceptions, which I haven't put in the slides, But first, the first one's pretty easy. It's permitted, the payment is permitted or required under the laws of the foreign state. The other one's a little tricky. It's the reasonable expenses exception. And so that's where the payment is to reimburse the foreign public official for expenses that they've incurred related to promoting your product or executing a contract. So for example, if you want the minister of such and such in the realm of Mordor to come see your great ring factory that you're building, and you need to pay for them to travel to the ring factory, that could be a legitimate expense. But, and there's case law on this, if you're taking, Sauron to beautiful Elfland, and maybe he spends 5 minutes looking at the ring factory, but the rest of the time he's enjoying himself in Elfland, that would be I like a colorable use of the saving exception, and it would really start to look like a bribe. So, what's the mens rea? This is a criminal offense. It's a true crime. There's going to be an implied mens rea of knowledge. So if I'm trafficking in a controlled substance, it doesn't matter if the substance is actually cocaine. If I believe that it's icing sugar, if I sincerely believe that it's icing sugar, I'm not guilty. So that's what the mens rea of knowledge means. Here it means asking questions like, did you know that it was for the benefit of a foreign official? Did you know that it was consideration for an official act? But wherever knowledge is a requirement in the criminal law, willful blindness can be substituted for it. And willful blindness means that you had a reason to suspect that something was the case, and you believed that further inquiries were appropriate, but you deliberately chose not to make those inquiries because you didn't want to know. And the classic case is somebody who goes on vacation and gets a very attractive business proposition to take a mysterious suitcase back to Canada and then drop it off for the friend of the person that they're doing this for, and they suspect that it's drugs, but they don't open it and they don't ask because they'd rather not know. So that's willful blindness. In the foreign bribery context, you might have willful blindness if a government official tells you that to receive a contract you have to pay a large bid fee, that's just part of the contract process, and you have to put it in this bank account, and you suspect that this is maybe a bank account associated with the foreign official, but you don't ask or make any other inquiries because you really want that contract, and you have an idea that this is probably what you have to do to get the contract. That would probably be willful blindness. And it's not just the offenses in the statute itself that you have to worry about. Because they create true crimes, you have all the other ancillary offenses in the criminal code that can attach to associated acts, acts in preparation, so aiding or abetting, and abetting means encouraging, conspiracy to commit the offense, counseling the commission of an offense, which is telling somebody you should really do this, it's a really great idea, attempts to do it that aren't successful, so you could have an undercover agent pretend to be a foreign government official, and if you agree to pay that person a bribe, even though they're not a foreign government official, that would be an attempt to bribe a foreign government official. Laundering the proceeds of bribery is also a crime, and possessing the proceeds of bribery is also a crime. So there are lots of other offenses around the margins of the offenses that are actually created by the statute. So how did the amendments change the statute in 2013? There's no more for-profit requirement. Before, business was restricted to for-profit enterprises. You remember that element of in the course of business. Now it includes basically any human undertaking. And so, for example, charities and nonprofits are caught. And this is significant because a lot of charities and nonprofits operate in countries where bribery is a problem, and sometimes it's necessary to get things done. And paying a bribe so you can get to a disaster area to provide relief certainly has a different moral quality than paying a bribe to get a lucrative government contract. But they're both crimes under this statute. Hopefully the former scenario would be a mitigating factor in sentencing, but they both give rise to the liability. And that leads me to the next big change, which is there's no more facilitation payment exception. A facilitation payment is a payment that that's demanded by a government official in order to do something that you have the right to. So for example, getting an electricity hooked up, getting water, having a routine license or permit issued. getting your passport stamped with a visa at the entry point to the country. Sometimes government officials will demand payments for those things, but those payments are regarded as facilitation payments. There used to be a carve-out for those payments, and it was eliminated, first in 2013 by the amendment, but then by the Governor and Council actually putting it into effect very recently in October. There's expansive geographical jurisdiction. Before, the Crown had to show a real, as Aaron told you, real and substantial connection to Canada. And that made it very difficult to prosecute where you were prosecuting something that happened entirely in Mordor, for example. But now, there's nationality-based jurisdiction. So if you're a Canadian citizen, even if you did it in Mordor and it was all the acts happened in Mordor, if you're Canadian or if you're a Canadian permanent resident, then you can be prosecuted. So this brings bribery into that class of offenses in the criminal code that are based on, where jurisdiction is based on nationality of the accused rather than on where the thing happens and what it's connected to. So I like to think of these as the supervillain offenses. So for example, if you want to hijack a plane or a ship, or commit a crime in space, or steal nuclear material, or go on a child sex tour, or commit terrorism, or take hostages, or attack the United Nations. These are all supervillain offenses. They're ones where the a jurisdiction is based on nationality of the person rather than where the thing happens. If you can imagine it happening in a James Bond movie, it's probably in that category. There are higher penalties. We go from a 5-year maximum to a 14-year maximum, which rules out conditional sentences. How do the prosecutions work? When will a corporation be liable? And the short answer is where a senior officer either is a party to it, directs others so that they commit it, or, and this is the most worrying one here, know that a representative of the corporation is going to be a party to it and doesn't take all reasonable measures to stop it. So we're going to skip here. Skipping through. Lots of vexing questions, but the bottom line is if you are a Canadian corporation and a regional manager in another country becomes aware that, for example, a third-party sales agent is about to agree to offer a bribe to an officer of a government corporation like an airline or an energy company, and the regional manager does not take all reasonable measures to prevent the agreement, it may be that the corporation has just committed a very serious criminal offense. So then you have dilemmas about whether to disclose, what to disclose, whether to do an internal investigation, and those are extremely difficult questions, especially if you're a public corporation and you have securities law disclosure obligations. So thanks very much for this.